Counterpoint. I'm Christine Argentine, one of your co-hosts of this video cast.
And I'm Paul Ivanek, also a co-host of this video cast, a partner in the Chicago office.
Today we're going to talk about something we've talked about before, but in a slightly different take. So we have a lot of discussions about wiretap allegations, pixels on websites, and how those are tracking users' movements on the websites, what they input, and how that's been alleged to be a wiretap, mostly in California under the California Invasion of Privacy Act.
Right, but there's been, there's obviously this federal Wiretap Act as well that, we've seen it, used by the plaintiffs bar, and then it's kind of gone away. But, it's starting to kind of come back, and we're starting to see some inconsistencies. So I think that's kind of what we're going to dive into today.
Yeah, and let's start by talking about kind of the differences between that California Act and the federal one, which made the California one so much more attractive. So under the California Wiretap Act, the California Invasion of Privacy Act, essentially it has this aiding and abetting provision where it says, you can be liable if you are aiding a third party in intercepting or eavesdropping on a communication.
Right.
And so that allowed lawsuits to essentially allege that the website owner was aiding the third party, insert name here, right? Whoever owned that pixel, that technology, to listen in on a user's communication with that website.
Yeah, because we're going to see the difference with the Wiretap Act is there's this really key part of one of the parties being the party involved, which is the website owner, gives that consent.
Right. And so under the federal Wiretap Act, there isn't that same provision.
Exactly.
And there is, under all the Wiretap Acts, this kind of general idea that you cannot eavesdrop on your own conversation.
Right.
Right? You can't be liable for eavesdropping on your own conversation. And that's in the California Act and in the federal one. The problem with the California one is you had this kind of additional aiding
and abetting. To kind of make it a little bit smoother for plaintiffs to allege against these website, the owners of the website.
So under the federal Wiretap Act, it provides for a private right of action against any person who intentionally intercepts, endeavors to intercept, or procure any other person to intercept or endeavor to intercept wire, oral, or electronic communications. Right? Pretty standard language under a Wiretap Act. And actually, California statute and many other statutes around the country, state statutes, are based off of the federal Wiretap Act.
California just added a little bit more just to kind of close the loop, I guess.
That's right. And California is, always a little bit more consumer friendly, providing for more protections there. And intercept under the Wiretap Act requires content, right? We've talked about content a lot before. And again, content means kind of that intention to communicate the actual substance of that communication, right? So not just record information, not just what page are you on, your address, your name, but actual the substance of a communication. And so again, when we're talking about what you traditionally think about in terms of a wiretap, right? Like, what is that phone conversation that's being had? It's a little bit more abstract when you're talking about a website.
Right. And then what is being captured out of that and conveyed and for what purpose? And that's something we'll probably talk about in a little bit here.
That's right. So the reason that we haven't seen as much federal wiretap is, again, because we don't have that aiding and abetting, and because you can't intercept your own communication. However, under the federal Wiretap Act, there is a crime tort exception.
Right.
Meaning, even if it is your own communication that you're intercepting, if you are doing it for purposes of committing a crime, committing a tort, injuring the party whose communication you're intercepting, then you can still be liable.
Yeah, it's it's that interception in violation of, a state or federal law. One thing that we see a lot of these decisions, talk about too is, the statute's text on that exception does not distinguish between, crimes or torts or the severity of either. So it's kind of just it's a little bit broad on that side.
Right. And so we're seeing these cases and we're seeing a lot more cases on both sides now, which has kind of opened the door back up for these federal wiretap claims in the Pixel website context, because what the crime tort exception says is the primary motivation has to be for the defendant's conduct has to be that crime or tort.
Right.
The determinative factor. It has to be a determinative factor that you, as the defendant, are trying to commit the crime or tort. And so there's been a lot of courts that have said, listen, these pixels are used for marketing purposes.
Yep.
The primary motivation there is monetary gain, marketing, but that's not a tort, right? Marketing's not a tort in and of itself.
Yeah, but so it's more of a deeper analysis. I mean, I think in kind of multiple fold, but how is it being pled in the complaint? Are the plaintiffs going far enough, or can they go far enough to allege the purpose of that pixel, the information being captured and collected there? Right. Was it for a gain in violation of, as the exception says, another federal or state law?
Right.
And then you look forward, whether or not the facts come out to show whether or not it was in fact being captured for that specific purpose in violation of another law.
Right. And so, where we have seen these cases survive a motion to dismiss on the basis of the crime tort exception is oftentimes maybe where there is some other regulation at play that the plaintiffs can plead that allows them to say there was an intentional violation of this regulation, and so that shows that you knew, right, that by putting this pixel on your website, it was going to, for instance, collect private health information, right? So we see a lot of cases in the healthcare space, not all of them. There's definitely cases on either side of either side there of denying and granting, but where there's a HIPAA violation alleged, right? And saying your intent at least was partially to commit a HIPAA violation.
Right.
Because you, website owner, should have known or knew that it was going to transfer private information. Now, again, it's all about, as you just said, how is it pled?
Yeah, because I could see, even if there's a fact-intensive complaint, it just kind of just broadly throws in, and it was in violation of HIPAA. I think courts will still analyze it to determine on its face, can you really reach that conclusion as the plaintiff? But obviously, as we said, there's a lot of different industries and a lot of different uses. If there are plaintiffs that can show that, point A to point B, this is being captured and collected, and this absolutely is covered under HIPAA, I think courts can say, hey, at least at the motion to dismiss phase until we figure out exactly what we're doing, because beyond that, you're going to have to show with facts and discovery why this information was being captured and collected, and was it truly, in fact, being captured in violation of another federal or state statute.
Right, that's right. And when you get into things like HIPAA or medical terms like medical information, right? There's really specific guidelines around what constitutes medical information and what doesn't. Look
at the definitions of HIPAA in and of itself.
Right.
It just goes forever. There is just a definition of a definition, and so some of that stuff really just says, all right. Plaintiffs might be able to try and complicate things early on, but it doesn't mean that at summary judgment, a court having all the facts and the law in front of them can't make the decision and dispose of some of these cases.
That's right. And I think where these cases really turn on, and what most of the primary allegations are about this URL that's being transferred, right? So when you've got these technologies communicating server to server, there's a URL that gets sent, right? And so really, it oftentimes comes down to what is contained within that specific URL. What words are in that URL, along with all the numbers and letters and whatever else is in there. And so, even if you survive a motion to dismiss, these have become very complicated at the class cert stage, right? Because when you're talking about a URL, now you're talking about, okay, well, what action did someone take on the website to actually transition information into that URL? It gets really complicated. So again, success at the motion to dismiss stage does not ever or always mean success overall.
Yeah, I mean, it's very telling because a lot of times we get, demand letters from the plaintiff's bar. Most of them, oh, well, motion to dismiss was denied. They don't go much farther beyond just motion to dismiss is denied, because what I think a lot of them are hoping is that the threat of having to go through discovery and the cost with summary judgment and class certification, should be enough to maybe leverage some sort of settlement.
Right.
And that all really depends on the type of exposure you're talking about. I mean, if the exposure is significant, then it's kind of can be sometimes a bet the company type situation, depending on, whether or not a plaintiff's attorney wants to settle at a reasonable amount.
Right.
And so, I mean, that's where these arguments are all going to come to play and complicate things. So it's not just because we're seeing this, the split amongst, the country on how this crime tort exception is applied does not mean that, it's a total loss. It's just, this is just one step.
Right.
There are multiple steps that we can succeed on still and have.
Yeah. But and I think one other thing I want to mention is that what's significant about the kind of federal claim coming back is we're no longer just in California.
True.
Right? And
True.
we're no longer just looking at California classes. These could be nationwide classes.
Yes.
And there's, not to get too far into the jurisdictional issue, but right, when you have a retail website that's selling things, oftentimes you can make a claim for jurisdiction in California under SIPA, regardless of where that company is based. But when you have more static websites that are more informational or more tied to a business like a healthcare business, it's harder to make that claim that, and we've seen most of those cases just against California businesses.
Right.
If we've got a federal claim, now we're outside, right, of California. Now we're looking at nationwide classes. And so the exposure, like you just talked about, now can be significantly higher, and it's a more significant decision for that company about whether or not we want to fight this, even, monetarily, right? Cost benefit analysis, even if we think at the end we could win on summary judgment, win on class cert.
Right. And I think strategically too, where the plaintiffs can file opens up a little bit more too.
Right.
If they, there's a few different options for them, and there's also something I think the defendants need to be aware of where they might want to move that case, as well.
Right. And you have different circuits making different decisions. So, it's kind of similar to the VPPA, right, which was the federal statute, video crime. We saw that kind of all over the country, and that different circuits were defining different pieces of that differently. We talked about, the definitions that the Supreme Court took up, So it'll be really interesting to see how far these federal wiretap claims make it and how far that crime fraud exception can be pushed, because it is supposed to be interpreted narrowly.
Right. Yeah, and going back to kind of just, with the courts, circuits being split and stuff, I mean, we think, there's a lot of case law where the plaintiff's, choice of forum is given less deference, where there is a nationwide class, which is huge for, I think, businesses to consider. There's a reason, and sometimes why a plaintiff will file in certain circuits, because they're a little bit more friendly to the plaintiff's side of the claims, and if there's a way to get out of that through a transfer because of a nationwide class, I think businesses need to be aware of those types of first steps to take in these cases to get them out of certain circuits if they can.
Right. But, the mitigation efforts on websites, those cookie banners, consents, right, that's still applicable with the Federal Wiretap Act, and so it's still important that companies are looking at, right, those steps that they could take pre-demand, pre-lawsuit to try to protect against some of this stuff.
Absolutely. Awesome. Well, I think that this will, we'll certainly see as the case law develops, and maybe we'll start getting some more circuits to start ruling on this crime tort exception.
Yeah.